Good morning, everyone. My name is Manoj Abhichandani, and I would be presenting our final webinar in the series of estate planning. And I welcome everyone who's attending today's webinar. Now, before I commence with the whole webinar, I just want to tell you that if you can't hear me, this is the best which I can do. So what you need to do is that there would be a phone number provided in your window. You need to call that number, and then you will be able to hear me very, very clearly. Now, I'll try to be a little bit louder, but as far as the voice is concerned, what you need to do is you really need to phone that number in your on your screen, and the webinar will last for about 30 to 40 minutes. So I am told it's a Melbourne number, but you'll have to check the number which is appearing in your little box there. Uh, Now, the reason why you're not able to hear me is sometimes because of the internet connection which you have, and if it's not a very strong connection, I'll try to be a bit louder, and I'll try to bring the mic. And believe you me, I'm using a very sophisticated mic here for this purpose, and I cannot go anything better. Some of you have mentioned that you can hear me now, so that's good. So let's just start, and to begin today's presentation, I was sent a joke, and I thought that I'd like to share that joke with all of you. And what really caught my eye was that the amount of money that's in your bank at the time of death is the extra work which you did, which was not necessary. So that really caught me. And sometimes we are hoarders. When I look at my wardrobe, I have shirts, I have clothes which I haven't worn for years and years, and I must actually throw them out. I must gift it away, and or get rid of them. But we are hoarders. We hoard stuff. We don't throw them out. And when you're no longer here, then all those things are not necessary, because and your kids won't take your clothes. They'll probably give that away to charity, but they'll want what you left behind. In fact, I've heard of a lot of stories where siblings actually fight with each other for what has been left over by parents, which is very, very distressing. And it's a very touchy subject, so I don't want to go too much there, and we'll just concentrate on the issues of self-managed super funds, and what you as an advisor or you as a trustee should be doing, so that your next to kin, your kids, get the maximum of whatever you have left for them. And the tax office uh, is um, with a little bit of planning, is a little bit at bay with all the inheritance which you will leave behind for your kids. Okay, so let's kick on and move forward. Um, uh, just a standard disclaimer to say that it's not financial planning advice. It is just a general advice, and you should just take your own personal circumstances in view before you make any decisions in whatever I have to say next. These are my contact details. If you want, you can write them down. If there are certain issues in my presentation, there is a window on your screen which has questions. So you can type in those questions, and at the end of my presentation, I will take some time out and I will answer them. So if you get if you don't understand a bit, it's best to put it in the question, and if you allow me to finish my presentation, I'll definitely get back to whatever you had to whatever you could not get through. Okay, now what I'm going to talk about is history of Superfund, especially since 2007, and payments, the form of payment like lump sum and pensions, and how they can be dissipated after your death or after your client's death, and how the next generation will get money from super, because the will which you have will generally not control money which is in super. Then how the payments are made, and what is a tax dependent versus who is not a tax dependent. So when I say tax dependent, means in the taxation law there is a definition of a dependent, and in superannuation law there is a definition of a dependent. So how payments can be made to tax dependents which can be tax free to them, whereas when payments from super are made to non-tax dependents, that is a person who's actually a dependent, but uh, under the tax act they are not considered as your dependents, and they can get money because in SIS act they can get money, but they will be taxed, and some will not be taxed, like former spouses and adult children, and I'm going to expand on that a little bit later. Now, payment of tax within super before paying death benefits. Now, this is sometimes not very clearly understood. And what happens is that if someone dies and he has a self-managed super fund, it's a compulsory cashing event. That means the trustees of the super fund must pay out the super benefit, but then there is no cash. So if there is no cash, then the asset has to be sold because the fund balance has to be paid out. Now, a fund balance is a balance where a set of accounts are done from 1st of July till the date of death, and any income earned while the member was alive has to be credited to that member account, and if any assets are sold, proportionately income must be credited to that member account. But what happens is if an asset is sold, it's possible that the fund will earn some capital gain, and capital gain tax will have to be paid before any death benefit has been paid. Now, prior to 2013 stroke 5, uh, what the tax office told us was that the pension ceases as and when the member dies, but then when the taxation ruling actually came in, they said that the pension can continue till it is paid out even after death. I'm going to talk about binding death nominations and when to use them and when not to use them. And this is one area where we are very negligent as advisors, I would say, because circumstances change for trustees. And when I was in practice, I sold my practice. I was looking after 600 self-managed super funds. Every year, I would take this binding death nomination out and discuss with my client on what he intended to do with it. And there were times, I'm talking about 6 or 7 years back, where it was thought that a binding death nomination has to be witnessed by two people and it lasts only for 3 years. And then later on, we found out that this provision is only for public offer funds, and self-managed super fund is exempt from this provision. That means we could have a non-lapsing binding death benefit nomination. So the annual event was not only to look after the accounts and the tax returns of the super fund, but also to discuss what would happen on death. Um, Now, whenever I used to meet my trustees, I had the impression that I'm never going to see them again, because you could literally die at any time. So if you did die, you had no opportunity to meet the client again. And I used to think that it is my last opportunity because I may not see him again. And this was my last opportunity to discuss all the options out. Now, legal personal representative is a person who will look after your affairs after you have died. So we need to discuss a little bit about that, and something to do with your trust deed. When does the trust deed evoke the appointment of of a legal personal representative? And since we are getting older, we are not dying, but we are losing mental capacity. And what that basically means is that a trustee should be prudent, should be able to make decisions. But when we get older, say 80s or 90s, it is possible that we may lose our marbles, as they say. We are not able to make decisions for the super fund. So what we need to do is we need to ensure that before we lose our marbles, before we get sick or sicker, we need to appoint another person, and that person most likely would be kids, or could be solicitors, could be planners, who would look after your affairs when you are sick. So that has to happen before, but then the trust deed issues have to be looked at, whether that would evoke automatically, whether the trust deed allows the appointment of a power of attorney to be appointed should a certain event happen, like a doctor certifying that you have dementia or some other matter with you when you are getting older. So, just as a history of super funds, we never had a problem prior to 2007 on contributions. We could contribute as much as you wanted. There was no such thing as a non-concessional contribution cap. You could, if you had money, you could put money into super. As far as contributions were concerned, they were linked more to the age. And I remember in 1990s, if you had 10 employees and if the age was say 25,000 each for 10 people, the total the company could claim was 250,000. And if for 9 employees and you were the 10th one, if you contributed 50,000 out of the 250, you could yourself could claim 200,000. So there was no limit on how much you can put in. And after 2007, the concessional caps came in on how much you could contribute and deduct. So that was a new problem for you. And the withdrawals were unlimited. You could withdraw as much as possible, whereas prior to 2007, that was always been a problem. There were some deductible and there were some non-deductible amounts which you could withdraw, and withdrawal had a bar and any amounts which you withdrew over a certain figure. So what Peter Costello did, he's just turned it upside down, and he said, it's not the withdrawal which I'm worried about. I'm more worried about how much you can put into super. And then he gave an opportunity where everyone could put in 1 million because everyone was complaining. Now, 2017 onwards, now we know in the budget it has been announced that unlimited withdrawals after 60 is still okay, but income in super will be taxed over a certain pension cap. So we would have an amount which is 1.6 million, transition would be 1.7, and will proportionately go up over the years. And then there's a new lower limit on non-concessional. So, we cannot put 180 anymore. It will be 100K. We'll be still waiting for legislation to come in, but I'm told that the concessional contribution will be limited to $25,000 for everybody, and then it may or may not go up. So what is going to happen, the results? And this is what I was suspecting a long time. And if you remember, the talk started when Julia Gillard, when she was the Prime Minister, she mentioned that any amounts above 2 million, would be taxed in super. So uh, I thought 2 million was quite generous for a couple that ended up to be 4 million. And if you are smart enough, you get 5% return, and that's a lot of money, $200,000 to be tax free. But 1.6 million is not bad, assuming that you could keep some money outside and still pay no tax, because there's no tax on up to $18,000 in outside of super. And then if you are 65 and over, there's other tax rebates, there are tax offsets, low income tax offsets, and there is also senior Australian tax offset. So about 35,000 can be earned outside super. So if you had $1 million, or say 800,000 on 5%, you could still earn money outside of super and pay no tax. But then we are now looking at funds, which are over 5 million. I have I had the good opportunity to audit some of these funds, which were above 5 million, and the attitude of these people was very different than people who have less than $1 million, because their issue was more to do with tax planning and estate planning in super, and they would have a big problem, because in what I have read in the three tranches of the information which the Treasury has released, is that you will not be able to segregate an asset. So let's say in your super you have $5 million, and you have asset, let's say two assets of $2.5 million each. So you have two properties of 2.5 million each. You will not be able to segregate them. So you'll have to do something, and I don't know what that something is, because your cap amount is 1.6 million, and you would need an actuarial certificate to determine how much is 1.6 million out of the 5 million. But then that one asset, the 2.5 million asset, how can that be allocated to your pension account, because it cannot be segregated, it has to be broken down. So this is going to be the next challenge for professionals. Now, going forward, let's talk about other issues. What are these death benefits payments? So who can receive them? Not everyone can receive it. You have to be a dependent to receive them. And how much you can receive, that's an issue as well. And when the benefits must be paid, because there are certain time limits where, and I'm going to talk about a little bit later about them, that we have to be careful. And we get only two times, to pay these death benefits. It must be paid in two installments. Now there's so many issues. We're talking about death benefit pensions or lump sum payments. So death benefits can be paid as a pension as well. You don't have to pay them out, but these pensions can only be paid to tax dependents, and tax dependents are like spouses. I'm not going to go into the definition of it, but let's say kids under 18, they can get a death benefit pension, and a lump sum payment can be paid to the tax dependents, and those who are not tax dependents, like adult children, are not tax dependents. So any kid who's under 18 is tax dependent. So if you have 25-year-old person, he cannot or she cannot be paid a pension. That person will only be paid a lump sum. And former spouses are included in tax dependents, but adult children are not included. Whereas in the superannuation definition, the SIS Act definition, it's pretty broad and says the children of the person who has died. We're going to talk about binding and non-binding death benefit nominations, and this is one thing which you must discuss if you are a trustee with your advisor. And if you're an advisor, this is like an annual event. It's like a tax return. I mean, we're going to talk about it every time when you see your client. Death when a person is on pension, it's treated differently. When the member is on pension, and when the member is in accumulation, it will be treated differently. I had a friend who died at the age of 49, and the spouse, he had a self-managed super fund, and his spouse had a home loan. So her first option, and I was helping her to work through the whole thing, we had to sell all the assets, and the spouse did not want a pension. She was not working, and she was looking after kids who were going to school. and the only thing she wanted was pay off the debt, and then she wanted the money to be paid out to her in a lump sum. So even though she could be entitled to a pension, she did not prefer because they were loans outside of super. So when you are in accumulation phase, it's dealt with differently, and you must also think that if you are the second one to die, so let's say your spouse is already dead and you are the second one to go, there are certain things in the SIS Act which you should be wary about. That is Section 17A. To be a complying superannuation fund, if you have individual trustees, there must be at least two individual trustees. And if you're a corporate trustee, you can have, if you are a single member fund, you can have one director or two directors. So you cannot have three, you can have two. So who should be the other person making the decisions while uh, uh, when you have literally kicked the bucket? So you have to make a decision who the trustees would be when your spouse is no longer with you, and how the death benefit would be paid, and who would be those beneficiaries. Now, if you have blended families, it complicates lots of things because you have dependents from the first marriage, you have dependents from the second marriage, and then you need to make choices at that point of time. Now, when you have a superannuation interest in a self-managed super fund, a tax-free component is basically non-concessional contributions or pre-1995 contributions. So those components are called tax-free components, but the taxable component is the deductible contributions which have gone into the super fund, the concessional contributions which have gone into the super fund, and the income of the super fund. Those are all called taxable components. We have a third component which is untaxed component. I'm not going to talk much about that because that happens mostly in situations where you have a government body contributing, and that they're basically unfunded funds where certain amounts are allocated to you, but they are paid out only when you retire as a lump sum or when you commence a pension at that point of time. But in a self-managed superannuation fund, you would have tax-free component and you will have a taxable component, which is a concessional component. Now, a lot of times when your clients or people, when they die, they are already on a pension. And the big problem at that point of time is that you have a pension document in place. These are basically terms and conditions of your pension agreement as a member, and with the trustee of the super fund. And you at the same time can even have a death benefit nomination, which is binding. So sometimes the trust deed has to interpret that if you die with a pension and with a binding death nomination, which which document out of the two document has to take precedence. So it can get very complicated if your clients are on pension phase. Now you literally have no problems. You don't need a estate plan when there are no blended families. So you're married once, you've got kids, so you don't have a estate problem. It's a very simple deal. You die, your kids get the money, or your spouse gets the money, or whatever, and life goes on. But that actually does not happen because the divorce rate is high. We usually have two spouses when we die. One is X, and then tax-free component in the deceased state. Now that is a situation when you don't have a problem, but we have seen that during your working life, the deceased would have made deductible contributions in super. So there are problems if there are deductible contributions, and death benefit beneficiaries are tax dependent, and that sometimes does not happen because, as I said earlier, payment made to adult kids, an adult kid is not a tax dependent. That means he does not receive a death benefit tax free. So a uh, tax dependent receives a death benefit tax free like your spouse, but if you leave your child if you leave your child who is an adult, and if you leave that child with some money from your super, that child will actually pay pay a benefit. Now, they're mostly cash and super, and that actually does not happen because mostly if you are accumulating or even if you are in pension, cash, although self-managed super funds are blamed to hold a lot of cash, but in most cases you will have uh, assets such as managed funds, and you will have assets like property in your super fund which has to be sold out. So you need some time to sell those assets because the pension continues till the money is actually paid out within a reasonable time. And if you look at the trust laws and if you look at the discretionary trust situations, a deceased trust situation, it is generally considered a reasonable time to be within 2 to 3 years when things are sorted out by solicitors, and the self-managed super fund can actually continue after the death, but the member can no longer be a member. The money which is owed to the beneficiary should be quarantined and not invested. And we're going to talk about how and who looks after that money a little bit later. Now, beneficiary wants a lump sum, and in most cases uh, wants to close the fund, but sometimes it happens that the beneficiary or the spouse is over 70, 75 years old, and they do not want a lump sum because if they get a lump sum, they can't stick it back into super, and that's a problem. And uh, being inside super is advantageous because if the amount is below now 1.6 million, it would be tax free to you. So sometimes if a lump sum is paid, it's very clear, but that is sometimes not the choice of the remaining beneficiary. They want the money to remain in super. So when does the problem start? Somebody has to die. If no one dies, you don't have a problem. As simple as that. So let's say you are somebody has died, but then you must be the beneficiary. So a payment has to be made from a superannuation fund after another person's death. So we're looking at section 307-5 of the Income Tax Act, and what we are saying is that because that other person was a member and they have actually nominated you as a beneficiary, and that's when it will hit you. Okay. Now, when the payment has to be made, a trustee regulation is required to must cash out the benefit as soon as practical after the member's death. And as I said earlier, you get only 2 times. So a self-managed super fund can make an initial payment to a beneficiary and a second payment after everything has been done. 3 payments are not allowed by SysReg 6.21. Now, sometimes what advisors used to do is that if a member died, then all they would do is if they both are in accumulation, they used to, with a journal entry, transfer the amount of the deceased member to the member who is not alive. But that's not okay because ATO ID 1523 clearly says that it must be paid out. So a paid out, meaning of paid out is it should be lump sum, or it could be a pension, or it could be a combination of two. So um, uh, what will actually happen? Now, I just want you to understand that the money cannot be retained in super after a person's death. Something has to happen to it. The assets need to be sold if there are assets. So you just can't leave it there forever and ever. Something must be done about it. And then we look after we're worried about the trust deed issues. What discretion does the remaining trustees have? And this gets very complicated because if there's no valid binding death nomination in place, then the discretion rules kick in. If there is a binding death nomination in place, then the remaining trustees basically don't have a choice. I've just been asked a very important question. I just want to pick that up. Do you provide the notes? What will happen is I'm recording this presentation, and we will send it to the professional bodies to assess it, and most likely this presentation will be assessed for 1 hour CPD, and once it is assessed, we will put it on our website. So I can see that lots of people have booked for the webinar, and they are not able to come in. So they should be. We will contact them, and we'll invite them to view the recording of the webinar. So going back to the presentation, which items you need to consider? If so, the first and foremost, the first thing you should be checking if your client dies is if there are tax. You have to check if there is a tax dependent or not, whether there's a spouse or not, whether there are kids under 18 or not. So this is the most important thing. And if it is, if the tax dependent is available, and we have to check with the dependent, what does the dependent want? Do they want a lump sum? Now, if they want a lump sum, so this is an annual event which you will have with annual meeting which you will have with your clients, and say, is your spouse, and situations change from year to year, and they may say, oh, I don't need lump sum anymore, or they may say, I need 100,000 lump sum, but the remainder I will take in pension. So if they say they want a lump sum, so make sure there's a binding death nomination is made. So the tax dependent is there, and there's a binding death nomination which is updated or renewed. Now, I get very surprised because sometimes I ask trustees, where's your binding death nomination? And they said, oh, we don't know where it is because we set up the fund by this accountant, and this accountant sold his practice and things like that. So these are very important documents, and they must be not only be with the permanent documents of the self-managed super fund, but they must be very safely kept by the dependent themselves. Like if you have adult kids, if you have 3 kids, you must give them your binding death nomination, because it is possible that your second wife may not hand it over to them. So they must know what the entitlements are from the state or from the super in case of their father's death. Now, if there is a tax dependent and they want the benefit to be paid as a pension, then make sure that the binding death nomination trustee allows the remaining trustee to pay such benefits after tax. I have seen so many trustees, and I noticed that the clause says that if there is a pension document, you can't pay a lump sum. So the discretion should be there with the remaining trustees, that if there is a pension, they should be allowed to commute those pensions and take them out as lump sums, and reverse. If there is no provision for a pension, then the remaining trustee must be allowed to actually commence a death benefit pension, from the deceased balance. So you must look at the trustee. This is a very important part of the trustee on how they dissipate the members' balance after the member dies. And if there is no tax dependent alive, then we have to look at who will get the money, and if they are over 18, then again we have to make sure that the binding death nomination is made to the tax dependent, because only lump sums can be paid. A non-tax dependent cannot be paid a lump sum, cannot be paid a pension. So adult kids over 25 can only be paid a lump sum and cannot be paid a pension. Now, sometimes when you receive this money, a death benefit, it is tax-free, and it is tax-free if you're a tax dependent. So it is received, and it's always tax-free. It doesn't matter what is the component of the payment. I'm not going to go into the untaxed component because that is not possible in a self-managed super fund situation. So it is non-assessed and it is non-exempt. So it is non-assessed, that's NANEI, non-assessed, non-exempt income. You receive the money tax-free, whether it is taxable or tax-free component. But if there are adult kids, they're non-tax dependents, the tax-free component, now when I say tax-free component, you should think about non-concessional contributions which we have made to the fund. And just want to say one thing: when you commence a pension, uh, and whatever the component is, taxable or tax-free, that remains through during the period of the pension. It is so if you withdraw a pension amount, it comes out in the same proportion according to the proportionate rules, and when the pension earns income, the taxable and tax-free components also grow in the same proportion. So when you withdraw money from a pension, it comes out to you as taxable component because you're still alive. You don't pay tax on it because you're over 60. But what you can do is you can contribute it back into super, and once the money goes back into super, the money always goes in as a accumulation account, as a and if there is no accumulation account in the self-managed super fund, the trustees must set up an accumulation account, and that accumulation account can be converted into a pension account. So you could have 2 or 3 pensions, but usually you would have two pension accounts. One pension account is 100% tax-free or non-concessional, and the second has a little bit of taxable component which you have to withdraw each time, and then you have to put it back in, and then for a period of time you will have a third pension. But then on the 1st of July, what you will do is on 30th of June you will commute the two. You'll end up the two pensions which are 100% non-concessional contributions, tax-free pensions, you commute them, and then on 1st of July you commence a new one. Instead of having 3, then again you live with 2, and you continually do that depending on how much you can contribute non-concessional. As you know, there's a rule about 3 years and bring forward rules, and that's all obviously going to change next year, so you have some opportunity to do something till the budget night, and then you have to look at how much you've already contributed in the previous 3 years, or whether you have triggered the bring forward rule or not if you have made a contribution above 180,000 in the past 2 years. So you need to look at that. But then the problem is that your adult kids, if there is a taxable component in your death benefit payment, they will pay 15% tax on that amount plus Medicare levy. So it ends up to be about 17%. So just to give you into perspective, what is 17%? If you had $1,000,000, it is $170,000. So it's quite a large amount. So these recontribution strategies are very, very important for you. So when there is no tax dependent left, it is possible. That means that all the kids have grown up, your spouse is gone, and you don't have anybody else. So recontribution should be the norm every year. Now, you should also think about if your spouse is still there. So with the new cap of $1.6 million, what I have read, what they are saying is that if your spouse is already on a pension, and then you die and you have a reversionary pension, your pension balance will increase your spouse's pension balance. So that bit, whatever you are transferring to your spouse, will not be tax-free in the fund. It will pay 15% tax on income. Let me just elaborate that with an example. So husband-wife situation, husband has 2 million super fund, wife has 2 million super fund. Both have breached the $1.6 million cap. Now the husband dies, and once the husband dies, and if it is a reversionary pension, then the wife does not only have her $2 million, she also inherits, or her balance transferred is now $4 million. So any amount above $4 million will be taxable. Any amount, I'm sorry, any amount above $1.6 million will be taxable. So taxable means that she would then need an actuary to decide how much portion out of that 4 million would be tax-free, and how much portion of that income above the 1.6 million will be tax to be paid as far as the income of the fund is concerned. Okay, so let's just proceed and talk about what are the options. The options could be is that out of that 4 million, it is possible that the spouse can actually withdraw the 2 million instead of keeping the second pension of the husband, and she could invest it outside of super and then earn income up to 35K tax free. And the second option which I am suggesting is even give it to the children, because it is possible that if she, out of the 2 million, if she retains 1 million, then she's left with another 1 million, then it is possible to actually distribute that money to the kids while she is still alive. So it doesn't form a part of the estate. Now, death benefit can be paid as an income stream. Now, it depends on the age. What we talked earlier is paying as a lump sum. Now, what we are saying is if you are over 60 and someone receives your death benefit pension, it doesn't matter what their age is, but if you are over 60 and you die and you want to receive the death benefit as a pension, then you can receive that as tax-free. And if the deceased pensioner was under 60 and the dependent is over 60, you can still receive it tax-free. But the problems are sometimes if the deceased pensioner uh, is under 60. Now that's going to stop very soon because the preservation age is slowly climbing from 57 to 58 next year. So very soon you will have no one under 60 who will be commencing pensions in about 3 years time. But if the dependent is under 60, then what happens is the taxable component is taxed at 15%, but the tax-free component of the pension amount is actually paid tax-free. Now, again, I'm repeating myself, children over 25 cannot withdraw a pension. It must be commuted and paid as a lump sum. So we're talking about dependents. If, let's say, a spouse, so you are 60 and under, and your spouse is 60 and under, and instead of getting a lump sum benefit, your spouse chooses to have an income stream. So the income stream will be taxed. The death benefit will be taxed in the hands of the beneficiary, which is not a good thing, because assume that that lump sum could be paid out to you and there would be no death benefit tax. And there's some time limits which we're going to talk about now. Now, taxes paid by the fund upon death. Now, this is when a deceased member is in accumulation, there's a CGT event, and I call it 10% tax, whereas the legislation talks about 1/3 discount. Self-managed super funds get 1/3 discount. They do not get half discount like individuals do. So what will happen is when the assets are sold to pay out a lump sum, and then these CGT events actually create this tax situation. So if you are going to have an asset in the self-managed super fund which is going to have a lot of CGT tax to be paid because it has to be paid out, perhaps it will be a good idea to discuss with the dependent to, instead of getting a lump sum, to be paid out a pension. But then again, you need to look at the trust deed, whether the trust deed allows a death benefit to be paid as a pension or not. Now, if you don't want to pay the tax to pay the lump sum because the asset has to be sold, you can, later on change your mind. And if you say, okay, I'll take it as a death benefit pension because I don't want to pay that tax. But then later on, if you change your mind and the death benefit pension can be commuted and a lump sum can be paid, but there are certain time limits, which is 6 months from death and 3 months from probate. So what I'm trying to say, a pension, a death benefit pension can be converted into a lump sum. But if you do not convert it within those periods, then the death benefit will no longer be a death benefit. It will be a lump sum payment coming out of the super, and you will be taxed, even though you are a tax dependent. So even a wife can be taxed. So a wife decides to take a pension, and then she decides, no, I need a lump sum, and she's not able to make a decision within that period, then any payments made by the super fund to her will no longer be considered as death benefit. It will be considered as a lump sum payments. Now, uh, of course, assets don't have to be sold if a tax dependent chooses to commence a pension, which can be the choice in many cases. Now, uh, if a deceased member is in pension, what we talked about earlier was that the deceased member was an accumulation. But if the deceased member is in pension, so the pension can continue till it is paid out. Assets don't have to be sold, and if they don't have to be sold if you're going to commence a reversionary pension, but if they have to be sold, there will be no CGT which will be paid. So the tax dependents and non-tax dependents don't have to worry about the self-managed super fund paying tax at the time when the member is in pensions. Now, if obviously, if the reversionary pension creates that $1.6 million breach, the reversionary beneficiary may have a problem. So you can stay under the cap. You can you can pay a lump sum, invest outside. There's another strategy which I was discussing with a client. The two members, husband wife, they had $2 million each. The husband dies, and the wife got a reversionary pension, but considering the new rules coming up, uh, because she will breach the 1.6 million, the fund was going to pay tax on any amount above 1.6 million to $4 million. So 2.4 million, any income on 2.4 million dollars was to be taxed at 15%. So what this lady decided was that she was going to upgrade her own home. Now you must understand that outside of super, any investment uh, by the deceased has a cost base. So if obviously the asset should have been bought after the CGT rules, but let's say if you die and you have investment properties outside of super, the cost base when you bought the property and at what price you bought the property actually carries on to the next generation. And when that investment property is sold, the cost base is actually transferred from the deceased to the person who has inherited those properties. The only exemption is to your own home. So what you could do, the strategy is this. So if you had 4 million and your cap was only 1.6 million, what you could do, so let's say you don't even have to wait till you die to do this. So let's say funds which have $5 million, and because the breach amount is 1.6 million, for a couple is 3.2 million. So if you had 5 million in the super fund, you could actually withdraw 1.8 million out of super, and you could upgrade your own home, because that 1.8 million, if it is transferred on your death to the kids, because it's your own home, will not be subject to any tax when it is passed on to your kids. So this is something which you should think about and discuss with your clients. There's another opportunity, because the definition does not only talk about dependence, there is interdependency situation as well, and it's a very complicated area because a tax dependent could be someone who is in an interdependent relationship with you. And the reason why it is important is because they can also receive lump sums which are tax free, and they can also receive income streams if they are interdependent, and you can shelter the assets of the super fund within a self-managed super fund situation if you could prove that there is an interdependent person. Now we're talking about when you have grandchildren. If you could establish that your grandchildren were, because your kids are over 25 and they're not tax dependents anymore. So we're talking about grandchildren who could be tax dependents for you, and then instead, and when you die, what will happen is that the asset which is in self-managed super fund, the income on that asset could commence a pension. Now, the second alternative to actually transfer that income is also having a testamentary trust. Now, a testament is a statement, and the trust is wakes up on the day of your death. So the testamentary trust is not alive while you are alive. The the testamentary trust becomes active when you die. And in that testament, what you can do is you can actually transfer assets which are outside of super, and you can, in your self-managed super fund, also have a binding death nomination to say to the legal personal representative. So from the super, you can actually transfer all the assets to your testament, and all the assets are actually held by a trustee of your testament, and that becomes a testamentary trust. Now, all the assets, if they are held in trust, the income can be distributed, or the income can also be withheld within that trust. It's how you design that trust is important. Now, a lot of kids actually challenge the testamentary trust because parents usually have the habit of actually locking the capital away while they don't mind the kids getting the fruit from it. So let's say we commence testamentary trust for with $10 million. So there's $10 million. The house is sold, all the assets are sold, the super, everything is sold and transferred into the testament trust. And let's say the kids are 40 and 45. They're two kids, and the testament is that all the income given to the kids half, and the the testament says that the capital is to be the 10 million, 5 million each to be given when the kids turn 65. Now that could be quite struggling for the dependents, so they can actually apply to the courts and get the testament reversed. So as long as you don't put these conditions which are so far-fetched that they may be challenged by your kids, and sometimes it's a good idea to have them in the discussion as well in your estate planning. What I suggest is those people who are thinking of setting up a testamentary trust is to have a discussion with the estate planner, start with the financial planner, and then search. And they're very hard to find a very good, estate planning who can draft out uh, a testamentary trust which will suit your particular needs. So uh, what is interdependency relationship? The SIS regulation 1.0 4A's that bracket 1 talks about it, that you should actually be living with the person, and the public should know that you have a relationship and there's some emotional support. And there are some private binding rulings where a mother was looking after the son, and she was not living with him, and she would look after him, and the son died, and she claimed that she's interdependent. And she was obviously, this is a reverse case. It's not the parent who died, it's the kid who died. And again, another private ruling, 75619, and it had the similar verdict. But there was another situation where there was a private ruling 67992 where the father was paying the costs of some not so necessary, but for universities, and they shared a common interest, and they would spend a lot of time together. And so it doesn't have to be necessities of life, it could be maintenance of a lifestyle. So if you have grandchildren, if they're going to private school and you're paying for them, you're picking them up, they stay with you on holidays, things like that, some interdependency can be established. But again, I'd like to remind you of the disclaimer. So what you need to do is you need to discuss these issues with your planner and look at all these conditions which you must satisfy before an interdependency relationship can be established. There's another ruling which is a private ruling, where there was a person, 25 years, he was living with his family at the time of death, and they were looking, their parents were looking after the kids, taking them to the doctor. So there was a close relationship, interdependency, and it seemed that they were working. And in this case, the superannuation was paid tax free to the parents. And there's another IT ADO IT 2005-143 where the cease was held, and they were having interdependency because the mother made financial contributions towards electricity, telephone bills, and she contributed towards mortgage payments. So there is a lot of things which you can actually do to ensure that not you who's dying, it's the kids who are dying. But then if you are the ones who are dying, you are helping the kids, so they are or grandkids who can be dependent on you financially. Now there are some planning opportunities, so you need to explore these opportunities. It's not the remember, it's not the financial necessities. It's also maintaining a lifestyle. So private school fees may not be enough. So you have to do lots of other things which you need to do when your kids get over 25. But then, as I said to you, there's another option out. The option is the testamentary trust. So there are a couple of options which you can take. Now, you can protect your death benefit going to the wrong person, and there are lots of cases, and they have been discussed in the second part of estate planning, and they're mostly to do with one of the children is trying to play foul, or the husband is trying to play foul, and usually it's in the blended family situation. So who should be the second trustee? This is a very important decision. So your spouse is dead and you are left. And in Katz versus Gossman, this is what happened. The sister became the trustee and there was no binding death nomination. See the problem? So there was no binding death nomination. The brother got nothing. She appointed her husband as the second trustee and she got all the money. The brother got nothing. And there's another case into Worcester versus Morris where there was a binding death nomination and the terms of the deed was that they were required to serve it to the trustee. But in this case, there was a mixed marriage, and she tried to withdraw the money after his death, whereas the kids held the binding death nomination, and she claimed that it was not served to her, and because it was not served to her, it was not valid. So again, I'm repeating the terms of the deed. So if you are a trustee yourself, this is the first thing you would be doing, checking your self-managed super fund trust deed and seeing what you can and cannot do uh, with your binding death nomination. So you have to. Once your kids get over 25, that's when you start making decisions. Or if you are in a blended family situation, that's when you start making decisions. Now, appointment of trustee after death. This is a situation where Section 17A requires minimum 2 individual trustees. You get 6 months to fix it. So on death, you are left, one individual trustee is left. So the trust deed has to be very specific, and it can actually automatically, it can force the other, because this is hardwired into the trust deed, into the remaining, it forces the remaining trustee to actually appoint the LPR as the other trustee of the super fund. Now, if there is only one wife, like no blended family, then it is possible that the legal personal representative, the LPR, is the same person, which is your spouse. But if it is a blended family, it is possible that your kids from previous marriage could be the trustee, or could be the trustee of your estate, or the legal personal representative of your estate. So it is possible that the second family, a second wife may block the appointment. So if you want to protect the rights of your previous kids, you must have a look at the trust deed. Now, at this point of time, I just want to mention the trust deed which we sell on trustdeed.com.au. We automatically the legal personal representative is automatically appointed, and the remaining trustees has no right to stop that appointment, and they must forcibly do all those things like sign as a new director or fill up those forms and lodge those forms, because they have the control of the fund at that point of time. Now, if there is a corporate trustee, if the last member dies, the trustee must allow the legal personal representative to be automatically appointed. Now, this is a situation where there's a one-member fund, and let's say the person has 4 kids. You cannot have 5 members in a self-managed super fund. So instead of appointing any one of them as the joint trustee, because a one-member fund can have only one additional person, that person can decide to have nobody. But what he can do is he can automatically appoint all 4 of them as legal personal representative, and all 4 of them take charge of the self-managed super fund, and all 4 of them can automatically become the trustee of the self-managed super fund. And there's a case where, which I want to talk about, Leopoldo Hesford versus Conti. Mrs. Conti died, and the husband changed the trust deed. He was the remaining individual trustee. Within 6 months, he took advice and he set up a company, and he was the sole trustee, a director of that corporate trustee, and he paid himself out. And and there were several places where Mrs. Conti had made a will saying that her kids of the previous marriage should get the money. She had made a will that her current husband should not get the money. But since there was no binding death nomination in place, and because her kids could not automatically become legal personal, could not become the trustees of the super fund, uh, Mr. Conti could do whatever he wanted, and he made sure that he withdrew the money, and the kids from the previous marriage of Mrs. Conti got no money. So these are some alert, some signs which tell you what you need to do. Now, let's just proceed and say you must read the deed before implementing it. So that's very important. I know a lot of people buy a deed because it's cheap, or a lot of people buy the deed, or they think that an expensive deed or from a particular supplier would be a good deed, and they would have the self-managed super fund, the solicitor who wrote that deed would have ensured that all these points are taken care of. But unfortunately, that is not the case. I've seen, I don't want to take the name, some of the very good suppliers of trust deeds, I don't want to take names here, have lacked on this point, and I think you really need to see what's sitting on your shelf, whether that provides what you want, because not all trustees are the same, and not all clients are the same, and their situations keep on changing. So it is possible that a deed may require an update, depending on what exactly your clients want. So I would suggest, if there's an advisor listening, I would suggest that to make this as an annual event, to go through the trustee, look at the binding debt nomination annually, and if a client doesn't remember you, that means he's losing mental capacity. So it will be your role to actually find out the names and phone numbers of the kids who could be probably living in a different state or a different country, to alert them that the trustees are actually losing mental capacity. And it's possible to get a trust deed to actually hardwired that if there is a medical practitioner who certifies that a trustee is losing capacity, that the next to kin or a certain person, you can name that person in that trust deed and say will automatically become will be appointed as a attorney. An enduring power of attorney will be executed, will be automatically executed, and the LPR will given the powers of the deceased member till the balance are paid out. So this is very important, and you must consider that. Now, when you're commencing a pension, this is again happens usually only once when the person reaches a preservation age. Now, the new rules from next year, again, it is only in the announcements and the various tranches which the Treasury has released. The transition to retirement pension would no longer be a reason where you can withdraw your superannuation interests. So what is going to happen is if you are working, you will not be allowed to commence a pension. You should not be working, technically speaking. And the definition of working is you should, or the definition rather of retirement is that you should be working less than 10 hours a week. So if you work less than 10 hours a week, you will be on pension. So it does not matter how old you are, it's when you actually give up work. Now, so it should be an annual event. So check if there's a binding death nomination in place. It can be non-lapsing. We've discussed that. Check if the pension is auto-reversionary pension. May not be such a good idea if the beneficiary already has 1.6 million. So if you have a pension which is a reversionary pension, this is again you need to discuss with your clients. Look, you have a reversionary pension. What do you want me to do? Because this new rule is coming from 1st of July 2017. And if there are taxable components in the member balance and he can still contribute, the contribution ages are up to 70, 75, depending 65. If you're working 40 hours, well, that is going to be shelved as well after 1st of July 2017. But if there is a recontribution strategy, if there is a possibility of a recontribution strategy, I think you should consider that because it's important to reduce the taxable component to the bare minimum and if it is possible. So implementing a recontribution strategy takes time because the bring forward rules are not applicable if the member is over 65. And I don't know whether you remember when the announcements were made in the budget, they were talking about lots of things. They're going to have only 500 non-concessional cap, and it was such a bad idea. And uh, it was such a bad idea that the government actually had to withdraw that from the pension. But we're still waiting. All of us are waiting to see what happens to the new rule when we are hoping that everything will be legislated and the comment period is already over. The 3 tranches have been released by the Treasury. Now just waiting for the final legislation to be drafted and released, and then we'll know more. Okay, now this is the last slide, and I've taken you a little bit over time. So we're talking about a real life situation. If you have more than 1.6 million super fund, you can consider 2 self-managed super funds. It's a good idea because you can't have more than 1.6 million dollars paying you tax free. So you can have a taxable fund and you can have a tax free fund. And if you have a blended family, maybe you can have 2 separate self-managed super funds. So just keep it separate, just easy. You don't want litigation, you don't want problems after your death. So what happens is whatever you want to pay to the previous family, you transfer it you into a self-managed super fund, into a separate self-managed super fund, and for the new family you have a new self-managed super fund, and you can roll over from the old super fund into the new super fund. So you can make the ex-spouse as the trustee and ex-kids as the trustee of the old fund and the new spouse to be the trustee of the new fund. Just keep it separate, and then consider handing over member balance above 2.6 million. So I'm thinking 1.6 million can remain in super and 1 million remain out. 1 million outside of super to the next generation. So either outside or inside super while they're still alive. So let's say if you're 70 and you got 2.6 million, your house is paid up, and 6.6 million gives you $130,000 income, say 5% income. I mean, you have to really consider that if you start eating the capital and the fruit is 130,000, the 5% of 2.6 million. I mean, how much of the tree do you want as well? So if the balance is over 2.6 million, you're 70, 75, you should seriously think, what is the point of actually holding all that money? It will be a good idea, and it's possible if you're 70, your kids could be in their 40s. It'll be a good idea to actually help them with their mortgages, help them. If you don't want to help them in today monies, you can contribute non-concessional into their self-managed super funds as well. So that could be something which you could think about. Okay, consider recontribution strategy. So we've discussed that contributions do not allow after a certain age, and corporate trustee, all adult kids, can become trustees and can become the LPR of your state, and they can hold enduring power of attorney if you feel that you're going to get sick. So there's something, and it's you as an advisor who has to look at the situation, whether the member is getting mentally incapacitated or not. And lastly, testamentary trust. Um, as I said, it's very rare to find a solicitor who listen to you, because a testamentary trust cannot be drafted off the shelf. You cannot buy from us because it is tailor-made. You actually have to identify all the assets. You have to identify who gets what, how much income, how much capital, at what age. So it's basically you rule from the grave. And just remember that the testamentary trust has to be um, so that it's not challenged, so that it's not so annoying that the kids have to actually take the matter to court. That's it, folks. I'm done. And just going back to where we started from, this is if you're 80, there's an old Chinese proverb which says that you give to kids with a warm hand instead of a cold one. What that basically means is uh, warm, warm, not a warm, uh, a warm hand, a moving hand which moves, and not a cold one, not after death. So that's that's the idea. Um, I have some questions here. I am now going to stop the recording of this webinar. I'm going to answer these questions. Those who have not put up a question, they can leave the webinar. Those who have put up a question, I'm going to type all the answers, and you will see the answers on the screen. I'm going to put all the questions and answers. So if you haven't put up a question, you want to see what other people are asking, you can actually stay online and you can see those answers as well. I thank you all, and this is our last webinar for this year, and I want to end it up with a very good news. As some of you would have known that ASIC um, had disqualified me as a self-managed super fund auditor. I have been given a news this morning that because I appealed under the provisions, under the administrative tribunal provisions, and we went through this whole process, and I've been given a decision today that AAT has considered that I am a fit and proper person, and I will be registered again as a super fund auditor again. So this has been a year and a half has been a very tough time for me, where I was pretty depressed because I've concentrated my whole life on speaking the truth and being a fit and proper person, and ASIC misunderstanding what statements I made to them. Um, I'm not at the liberty to talk about the whole thing, but we have to wait whether ASIC will appeal uh, the decision of AAT, which I think is 21 or 28 days. and by God, I'm going to make a lot of noise about that. Thank you very much. Bye for now.